You're listening to Worksights, insights about the American workplace, workplace law, and the future of work. This podcast is produced by the Noble Law, an employment law firm with offices across the United States, and is hosted by managing partner Laura Noble, a recognized leader in employment law with over 20 years of diverse legal experience. This podcast is not intended to be used as legal advice and does not establish an attorney-client relationship with its listeners.
Hello and welcome to the Noble Law podcast, Worksights, where we take a deeper dive into all things affecting the intersection of law and the workplace. Today, we are going to talk about mediation, and we'll go into that with someone who has become well known to our firm as our sort of go-to mediator. I'm very excited today to talk to Steve Dunn. He is an attorney and a certified mediator. Before becoming a mediator in 2019 as a full-time gig, Steve practiced employment law in Charlotte for over 20 years. His practice included FLSA, wage and hour, trade secrets, non-competes, and all forms of employment discrimination. He represented a range of clients from individual executives to Fortune 500 companies, and he worked in several industries such as financial services, education, manufacturing, technology, construction, marketing, retail, and motorsports. Through his representation of cities, counties, and public colleges, he developed an appreciation of the unique needs of public sector clients, including the First Amendment, public records, and constitutional torts. After becoming a certified mediator in 2009, he quickly realized that dispute resolution suited his experience and ability. So he became a full-time mediator and arbitrator in 2019, and he now works with Miles Mediation and Arbitration in Charlotte. Welcome, Steve, and thank you for joining us.
Thanks for having me.
So my first question was going to ask you about your journey to becoming a certified mediator. And I'm not going to throw away that question because I want to dig more into beyond the bio. Sort of what was it about mediation that you found so appealing that you gave up your law practice basically to do it full time?
Well, to start, I have to confess that I was a skeptic of mediation in my first several years practicing law. I did not understand why I, as a lawyer, couldn't just call my opposing counsel and just say, like, this is what we're willing to do. Yeah, are you going to take it or leave it? And I had the great fortune of participating in a very difficult mediation as a lawyer involved in a very complicated family dispute that involved a business that was breaking up and real estate and intergenerational grievances that had existed for decades. And a wonderful mediator in Charlotte named Gary Hemrick handled that case. And when we went into it, we all thought that there was no hope that it would settle. We were only participating in mediation because it was required by the court. But I observed Gary that day add value as a mediator, and he was able to put the pieces together in a way that none of us had thought of before, and we successfully settled that case. And that was the first day that I realized that a good mediator can really make a difference. So I went, the next step was to take the 40-hour class, which I did with Andy Little in Chapel Hill. And I did 2 observations of other mediators in their work and became certified in 2009. And since then, I just started growing my practice slowly but surely over the years until leaving my law firm in 2019. And the reason why I like it so much is because it is all the fun parts of being a lawyer, by which I mean talking to people and hearing about interesting situations and being persuasive, recognizing issues and talking them through, speaking the language of litigation, but without any of what I regarded as the downsides of being a litigator, such as lacking control over my calendar and really the stress and anxiety that goes with having ongoing responsibility for cases. So for me, it's been an ideal mix of the things I like about the law, and I've been able to sort of take out the parts I wasn't so crazy about.
Well, first of all, we're delighted that you made that choice because we've really thoroughly enjoyed you as a mediator. I think all of the lawyers in the firm have worked with you at least once. And in terms of the fun parts of being a lawyer and the not so fun parts, what I like about mediation is that you, if it's going well, are not screaming at each other. And there's so much other times in litigation that's so aggressive and contentious that it's a nice opportunity to actually be engaged in some problem solving with your adverse and opposing counsel. So in 60 seconds or less, for those who are not familiar, describe what a mediation is.
Mediation is an occasion for talking about settling a dispute. And it is a structured conversation about resolution where you have your mediator, who is a neutral third party, someone who has no interest in the outcome of the dispute, facilitating that conversation. And that's really all it is. Everything else about it has developed. We've developed a lot of traditions and rituals that go around it, but at its bare essence, that's what mediation is all about. It's an occasion for getting together to do the specific thing of resolving the dispute.
So when I describe it to my clients, I tell them we have this big conference room setting where all the parties sit together and look at each other, and the mediator says a bunch of things about what mediation is, and then everybody goes off to their separate rooms, and then the mediator does shuttle diplomacy back and forth between the rooms. Just so like a logistic visual picture in your mind of what it usually looks like. Now that's all been changed by COVID and Zoom mediations. And we can talk about that because I think your experience has been that those have been pretty good, whereas I still sort of old school like to be in person. But I do want to tackle this from the perspective of a plaintiff's attorney. Obviously, that's where I'm most comfortable talking about this. You were a defense attorney for a long time before you became a mediator. From my viewfinder of the plaintiff's bar, I think a lot of times plaintiff's attorneys go into that mediation thinking that they are at a systemic disadvantage, that the defense attorneys have all the money to give away or not. They have the lawyers, they're big white shoe law firms, they have the resources, they have the third-party vendors, forensic examiners, et cetera. And so the mediation is an extension of that lack of control. And so plaintiffs walk in feeling, well, we'll just see what the defendants are going to do. They've got all the marbles and they're going to decide how this thing plays out. Do you share that perspective? And if so, why? Or if not, why not?
I think every situation is unique. There are many cases in which, particularly in the employment context, where you have an individual who's an employee or a former employee bringing a claim against a corporation that is often a large corporation, but not always. There are cases involving defendants who do not have endless resources at their disposal, but there is a way in which what you're saying is true, which is that a plaintiff can always choose to settle any case, really. Whereas the same is not true for a defendant. You can always, as the plaintiff, decide to settle simply by coming down as far as it takes. Whatever the defendant is willing to put up on the case, you can, as the plaintiff, make a choice to accept that. And so in a way, it probably feels as though you're always the one who's kind of responsible for traveling the great distance until the deal is finally done. I can tell you that the feeling in the other room is much the same. Usually both sides feel the same about the process, which is that both parties usually feel like they are doing their best to be reasonable and to put the case into a range where it should settle, the proper range in their view. And they almost always, on both sides, feel as though the other side is not responding in kind, that the other side is being unrealistic or unreasonable. So as a mediator, I often feel as though I'm very much working on both sides to move them toward where the case needs to be to settle it. And it often feels like some sort of flexibility has to exist in both rooms. I'm very commonly encountering a situation where folks show up to begin the process with certain ideas about what needs to happen in order to get the case resolved, and both sides having to revisit those ideas. And maybe in some way it's easier for a plaintiff to do it because there's less bureaucracy involved, there's less layers of approval that need to be gone through. But it's often required in both rooms. There needs to be some change to occur to get the settlement terms into a place where they're going to be acceptable on both sides.
No, I totally agree with that. And I think that plaintiffs, attorneys, and clients do themselves a disservice when they cede control and direction in the mediation, precisely for the reasons you've just described. A plaintiff can always just withdraw the claim. They can voluntarily dismiss their claim and walk away. Now, that's obviously not usually an ideal outcome for the plaintiff, but in terms of measurement of control, that's a significant amount of control, right? More importantly, I think that because of this perspective, a lot of plaintiffs' attorneys don't take advantage of preparation that could really improve their position, their arguments, their outcomes in the mediation. And I wanted to talk to you about that a little bit. Tell me, why, if you agree that preparation is important before the mediation, and if so, where have you seen it sort of gone off the rails when folks haven't done the preparation before they step into the room?
I think it is important, and I try to facilitate that as much as I can in my own practice by as often as I can possibly can. I like to get on the phone with the lawyers from each side in advance of the mediation. Some of that is to help bring myself up to speed, but a lot of that also is to make sure that the lawyers take advantage of the opportunity to think about the case before we get into the mediation. And preparation can be as simple as refamiliarizing yourself with the facts, but I think most importantly is to be thoughtful in advance about where the negotiation is going to go from your room, where you think it should be headed and how you're going to get there. And I guess the disaster scenarios that I've seen are ones in which there's been no thought given to what damages are recoverable at the end of the case, or what are going to be the costs of litigating the case moving forward if you're coming from the defense side. If there hasn't been any conversation about how this thing realistically could end up if it gets litigated through trial, and then you have to do that work on mediation day. And we certainly will do whatever we need to settle the case, but it helps immensely if you've thought it through and talked through with your client, here's what winning looks like. And knowing that the mediation day is not about winning, but rather compromising on that winning scenario in exchange for getting the certainty of the resolution and having it be over on that day.
How do you feel about getting briefs ahead of time from counsel and other documents?
I'm a big fan. I like them. I always review whatever is sent to me. I have found that the most helpful submissions I get from the parties are letters in a conversational style about what happened here and how it's going. So legal briefs are fine, except it's a very rare case in which I'm going to go and pull the cases that you cited and actually read them. That's quite unlikely, unless there's some gangbusters issue that one side or the other feels really strongly, that there's no debate about. Normally, what I'm looking for is what are the claims, what happened here, but also just things like, what are the personalities of the people involved and how are we coming into this decision? Because there are often factors affecting a party's settlement position that have little or nothing to do with the actual case itself. There may be a personality involved, whether that's a business owner or the plaintiff's personality. There may be conceptions of fairness and justice that need to be taken into account. Sometimes there's structural things in large companies about like just as something as basic as whose budget the money is coming from. Well, sometimes insurance coverages, there are things that affect the dollars that are available that may or may not have anything to do with the case. And so any light that you as the lawyer can shed on those types of things for me, I always ask, frankly, how it's going working with opposing counsel, because I just like to know, if it's, Laura Noble is a real pro. We're getting along fine. We got some discovery stuff we still need to work through, but all in all, everything's good. That's fine. We can work with that. But on the other hand, if it's really bitter and acrimonious, or if there's really nasty motions being piled against each other, it's also nice to know that before we walk into the room.
Oh my gosh, for sure. And I wish that I could say that I have never gone into a mediation with a fear and loathing in my heart for opposing counsel, but that would be a lie. But those are few and far between. At least I can fess up to that. It makes for a very challenging mediation. I want to talk about client preparation for the mediation, because in addition to lawyers failing to take the opportunity to really dive deeply into the facts and applicable law of their case, I think many, on both sides really, but I can speak from the plaintiff's bar, don't do a thorough enough job explaining to the client what mediation is, what it is not, and what their role is, what the role of the mediator is and the attorney is, and that can throw up some barriers at the very end when you're really close on the numbers.
Well, I always like to explain a bit about the process at the beginning. As you know, we're required to mention a few specific things about the process when we get started. And I have my own, what I call my flowery words of encouragement about the process that I like to give to people at the beginning and also on an ongoing basis throughout. I see a big part of the job as cheerleading and coaching and just keeping us engaged and keeping us from giving up. Because I've seen time and time again how, as dark as our prospects may seem in any given moment, that breakthroughs can occur. And there's been so many situations in cases where nobody thought that we were going to be successful, but we ultimately were, that one of my biggest jobs as the mediator is just to remind everyone of that and keep us going. So I think that's a big part of the job. As far as preparing the client, I'm suggesting more and more now that we get away from what I think is the very common practice of preparing with a bottom line number in mind, right? So it is, and I did this as a lawyer myself, so I'm guilty. But I think that both plaintiffs and defendants tend to come into mediations with a number in mind, and the notion being, well, as long as we can get to that number, then we'll settle the case, and if not, then we won't. and that's okay. I mean, that's better than no preparation. But I prefer to think about potential outcomes in ranges. So it could be as simple as 3 ranges. Like you might have the most desirable range, which is the range at which absolutely no questions asked, will definitely settle the case if we get it into this range. And then in the middle, you might have the range where you're going to have some hard decisions to make, like the really got to talk about it and think about it. And maybe if we settle in there, it depends on what comes out during the mediation or how we feel, whether we learn anything new. And then at the other end, you have the range where presumptively you're really not going to be interested, where it's more likely than not that you won't settle the case if the party on the other side can only get into that range. But even there, even in that unfavorable range, I like to provide in advance that we're going to talk about it. No matter what the final option seems to be, we owe it to ourselves and to the process to talk about it. And it might be a short conversation and it may not require a lot of thought, but we're not going to have a line in the sand that if it doesn't get crossed, we're not even going to have a conversation. Because, I always refer to it as the mediator's dirty little secret is that most cases get resolved with both parties being in that unfavorable zone. It is the great majority of cases that we wrap up where everybody kind of hates the deal, but it's
Right.
just barely acceptable enough. And that's where the magic happens. And I think it's those types of cases where a mediator can add value to the process, because there is no obvious solution. I say to parties all the time, we know this is a hard case, because if the outcome were obvious, we already would have figured it out and we wouldn't even need to be here. So the fact that it's hard is to be expected.
Right. And that's actually really good advice about preparing your client for what I really liked what you said is what we may learn. So, again, from the plaintiff side, they have the facts from what they experienced and their discrimination, wrongful termination, et cetera, which of course the employer denies. But one classic line we always hear is, wait till we get to depositions because everyone in that office is going to support me. And then lo and behold, Mary in accounting did not like you and did not think you were a good performer and is not going to be supportive of you. And we don't learn that oftentimes until the mediation if it's pre-discovery. So before we're doing those things. So you may learn things in the mediation that really does change your mind about the value of the case. And if you don't prepare your client for that eventuality or that likelihood, it's going to be harder to get them to where you think they ought to be going.
I think that's a great point, and it reminds me of what you were asking about before, about whether defendants are really kind of controlling the process because they are usually the ones that have greater resources at their disposal. And I can tell you, I know that you are a certified mediator as well, and what you'll find is that those defendants and their insurance companies and their executives and their lawyers are a lot of times they are going to come in with some sort of a threshold or a bottom line. And if there's going to be movement on that, they're going to need to know why. They're going to have to justify it to maybe it's people who are not even in the room, that they're going to have to explain, how come you came here to settle it for X and then you ended up settling it at Y? And it will a lot of times be put to you directly as the mediator. Phrases like, I haven't heard anything new today to affect my analysis of this case, or this is where we are on this case based on X, Y, and Z. Tell me why I'm wrong. I've been asked that a number of times. Tell me why I'm wrong. And that is a moment in which you as the mediator have to take a deep breath and answer that question in a compelling sort of way. And if you do, if you got something to say and you're able to say it, then that's the sort of thing that can move the needle in a room like that. And it may just be as simple as telling the plaintiff's story in a way that the defendant hasn't heard it before. Even there might not be any new facts, there might not be any revelations about the evidence, but if those folks can just hear the story told the way that it would be told at trial, the summary that might be given in a closing argument at trial, I find those moments can be really effective in shifting people's positions.
There's so many good nuggets in there that I want to get into. One, I tell new lawyers who are doing this for the first time to look at their opposing counsel as partners in problem solving. And when they ask you questions, do your best to answer them. There tends to be this idea of, no, I'm going to keep all my cards close to my chest. You plaintiff have the burden of proof. You have to convince these people to open up their wallets. They're not going to do it because you say you really ought to. You have to give them something. Now, you have to do it in a way that doesn't blow up your strategy, of course, but ultimately you're going to be the one who's putting on this evidence. So now is the time. If you think you're going to get close, push them, answer the question, give them what they need, give them something. The other advice I give them is do it slowly, though. Hold on to those little nuggets and give it dribs and drabs because it keeps the conversation going. And the longer you're all sitting there and talking, the more likely you're going to get to somewhere. I want to talk about opening statements because there is I think, growing trend to eschew the opening statement in the mediation. And for those of you who aren't familiar with opening statements, in that everybody meets together in the big conference room, general session, each party has an opportunity to make a statement about their case. And certainly there are times when the issues are so hot, like a sexual harassment case or an assault case, where nobody wants to talk about anything and everybody has to be separated. But I think that there can be times when you, as the plaintiff's attorney, can be very matter of fact, not emotional, and lay out your case so that they can see it all at once as it would be told to a judge or a jury, and that can be effective. What are your thoughts on that?
I agree completely. I think at some point in the process, it's important for each side to hear the other side's story told about as well as it can be told, and so that they really know what they've got. And if we can do that in the opening session, if the lawyers can do that, and sometimes the parties will speak on their own behalf, if we can do that in a joint opening session, then that's great. And I think it helps us settle cases a lot. And as a lawyer, when I was practicing, I would never willingly forego the opportunity to deliver some kind of an opening statement like that. I always took advantage of that opportunity because I regarded it as one of my one and only chances to speak directly to the party on the other side. Never mind the lawyer. I talk to the lawyer all the time, but this was my one chance to speak to the party on the other side and to let them know where we were coming from in what I consider to be a calm and reasonable way. Matter of fact is a phrase that you use that I agree with very much. I think that's the way to do it. And I wonder if sometimes the folks who I was litigating against, that was the first time they'd heard the story told in that way. And so anyway, if the parties can do it during an opening session, I'm all for it. But if not, sometimes the mediator has to take over that role and do it for them. And sometimes, depending on the personalities that are involved, that opening session can be counterproductive. I have had horror stories where I've made my flowery speech of encouragement about the process and then turned it over to the lawyers, and they just launch into tirades against each other about their motions for sanctions and how wrongful and unethical they are. And it gets us nowhere. And it may even move us backwards in the process. And so that can be counterproductive. So on the issue of whether to do a joint opening, I generally, I'm slightly biased in favor of it, but I always defer to the lawyers because they're the folks who are in the case, who know the clients, and who know if it's likely to help us or hurt us in getting the thing to resolution.
Is there any side that is more guilty of the fire and brimstone opening statement than the other?
I really don't think so. I think it just comes down a lot more to the individual attorneys' personalities and litigation styles. I've seen incredibly effective advocates on both sides of the fence, and I've seen folks make unhelpful presentations on both sides of the fence.
Right. I always think that, when I hear that kind of opening that you're making your closing to a jury, sometimes I think, well, maybe they're doing that for the benefit of their client. They're having some sort of client management issue and they need to demonstrate to the client that they're their zealous advocate. But even with that, that is a horrible way to mend that, client relationship, because it has the effect of putting you back, 4 steps before you can even get down to the good, juicy part of negotiation and persuasion. I was in a mediation once with a horrible sexual assault, I have to say, legally, allegation. And the opposing counsel opened with my client being a liar and shedding crocodile tears at her deposition, which will draw their defamation counterclaim. And I thought, well, even if that is true, how does that help us here today? Because then she got up and stormed out, and then it took us an hour and a half to even get the parties back to the table. Like, it just was not helpful.
I will tell you, I've been thinking a lot lately about this. It's kind of a related question. And I should also say that being a mediator is just like being a lawyer in the sense that you get better at it with experience, but you never know all there is to know. Like you're always like learning new stuff. And so I've just been thinking very recently about talking to lawyers and parties about using mediation day as a day to really focus on resolution and compromise, as opposed to every other day in all of life when you can focus on winning and defeating the other side. And what I mean by that is that I would say the vast majority of parties come into mediation feeling the need to convince me of the rightness of their position. And I guess through me somehow convince the other side of the rightness of their position, or at least of the risk of an adverse outcome on the other side. And so we often spend a lot of time in mediation. I spend a lot of time just hearing about how great our case is and how strongly we feel about it, and how, I, Steve Dunn, should agree with that, and the other side, if they're really evaluating this thing correctly, should also agree with some of the points that we're making. The effect of that can be to spin up the litigants in a way that is kind of counterproductive to the process of trying to settle the case. Then what I've started thinking about moving toward is the idea that, look, you got every other day in the whole history of this whole thing to go on and on about how great your case is and how strongly you feel about it and how you're right about everything. Every other day, that's the right thing to be doing. But for today, why don't we all agree that we're trying to get this thing resolved and think about it in a different way? And I don't know exactly how to do that, but I've been thinking more and more about the need to do that, because I think you're right that when people make a pounding on the table sort of production, sometimes that's good for showing your client how in their corner you are and how capable you are of arguing zealously on their behalf. But I think it sometimes takes that same client out of the mindset that they need to be in if we're going to have a chance of settling the case.
I love this concept of mediation day. I don't think I've ever heard it referred to like that before. And I like that idea that it's almost sort of like a ritual. People behave differently at Thanksgiving dinner table than they do at Tuesday taco night, right? Because you have all of this ritual around it and people getting dressed up and they sit down and they light the candles and they do all that. So mediation day as this structure that actually enables people to get into the mindset of resolving this problem, resolving this conflict.
I think it's a powerful effect. I think it's one of the reasons why mediation succeeds in settling cases that haven't already settled on their own. I will sometimes say to folks, it's like if you're going to a football game, you go on a Sunday and you put on your Cam Newton jersey and you go to the stadium. Or if you're going to work, you put on your work clothes and you go to your office and you sit in front of your computer. And if you're going to settle a case, if that's the thing that you're doing that day, well, you dress a certain way, you go to a certain place. And the key that I think gives that essential energy to the process is that it is the one moment in the history of a lawsuit where everyone who's involved is trying to accomplish the same thing, as opposed to trying to accomplish opposite goals, right? So it's the one day where the plaintiff and the plaintiff's lawyer and the defendant and the defendant's lawyer and now this mediator who's the new guy are swooping in, and we're all trying to do the same thing, which is to settle the case. And if it doesn't work out, then you can go back to trying to accomplish opposing goals tomorrow. But for today, let's look at it through this lens.
Do you use that in your speech now?
I do mention that because I really do think that it is a big part of the reason why mediation works. And I'm absolutely convinced that mediation does work. I think there's power in just having the item on your calendar and just knowing, okay, 3 weeks from now, I got that mediation in this case. That's the day we might settle that case. And that your client's thinking about it. And then the week of, it's all right, Wednesday. That's where I'm going to be and what I'm going to be doing. And then Wednesday comes along and you're like, okay, I'm here now. This is what I'm doing. This is the day that I might be able to settle this case. I think that energy is essential to the process.
That's such good feedback, because oftentimes with my client, or sometimes recalcitrant opposing counsel, I'll get what do we need a mediator for? We can just talk through this. We're smart people. We can resolve this. And I haven't articulated as well as you have, but there is something to the process and committing yourself to that process and that process alone on that day with your client and everybody else there that puts you in a different mindset that maybe makes you more likely to be open to the possibility of taking one of those unpleasant outcomes you referenced before?
Well, and I in addition to all of that, I would say reasons to consider mediation, even though you might not think you need it, there are many, but a couple are that one, you might think of something new. I mean, if the mediator is good and helpful, then there's something about a fresh perspective that might actually be illuminating. You know, the new person on the scene might actually have some insight about the thing. But even if not, even if the conversation is just a rehash in a way of all the things that we already thought about the case, it can be extremely helpful for the clients involved to hear it from someone else, right? Your opposing counsel might be more receptive to the same message coming from me as opposed to coming from you, just because I'm not out to get them. I'm a neutral person here. And meanwhile, your client sometimes may have heard you say something 50 times, but not really believed it. You know, it just might have wondered like where you were coming from, or if you were, really shooting straight with them and stuff like that. Whereas if I come along and I've got a good rapport with that client, I've established myself as a credible, straight talking type of person, and then all of a sudden I'm saying some of those same things that client has heard before, I think it can help, really bring them around to realizing that, okay, all right, this has some merit.
No, absolutely. And I've seen that in practice where it's kind of like when you tell your kids something 42 times and then a trusted coach says the exact same thing. And it's like wisdom from the heavens fell down on them. Wait a minute. Yeah. I've been telling you that for 6 months.
Yep, that's right. I mean, it might be like a weakness in your case, but I think a lot of times it just comes to how you're computing damages. I think a lot of times folks have got ideas about what their damages are that just don't happen to line up with the way that the court system measures damages in their particular case. And so if if you've been saying it to your client and then opposing counsel says it during the opening session, and then it seems like the mediator tends to agree, then that can sort of, it can help. And it's not a matter of like manipulating people in any kind of way or trying to trick people at all. It's really just a matter of giving people confidence and assurance that they're making a good decision. Because a lot of times people they're not sure, like if this is a good outcome or not. They don't know who they're supposed to trust. And I think that participating in the process can help give people confidence to move forward through the end of this dispute.
One of the things I think that we're tiptoeing around here is the conventional wisdom about the role of mediator versus what I think we're seeing more and more in practice. So the conventional wisdom is that a mediator is a neutral facilitator, the proverbial water carrier. They're going back and forth between both rooms. They're reframing things in a softer way, or they're, helping people push back and formulate questions, et cetera, et cetera. But they have no opinion about what the ideal outcome is, or even what a possible outcome is, and they would not share any opinions under pain of death. What is your philosophy about the role of mediator, and how do you feel about your philosophy versus the conventional wisdom?
That's a really interesting question. I think that mediators are like lawyers in the sense that we're all people and we're all different, and our personalities and our styles inform the way we do our work. That's certainly true for lawyers, and it's definitely true for mediators too. I know that as a lawyer, I preferred the mediators who I believed and I preferred to use the mediators who were actively involved in figuring out how to resolve the case. And that's the example that I gave you before about that one with Gary Hemrick. I mean, he truly was able to see the whole chessboard instead of the very limited part that we as lawyers were focused on. And he was an active participant in suggesting ideas and bouncing things off of us to help us think it through, and that ultimately got it resolved. And so I tend to try to be more that way. And there is a style of mediation, and this is arguably what we're taught to do, I think what you're describing is a more passive style and more of a like, hey, I'm just here to facilitate the conversation, and whatever you do is fine. And but here's reality: the parties almost never are deeply experienced in litigation and don't know if they're getting a good deal or not. Right? They just don't have any way of evaluating that, and sometimes that's true for the lawyers as well. It is not to be assumed that every lawyer knows what they're doing and across the board in every I mean, there's a lot of folks who
Wait, what?
Yeah, well, it's hard to believe, I know, but even the best of us occasionally will run into something that we haven't seen before or haven't thought through or just weren't aware of. Or even if you know the case, you just don't know like what's realistic to expect, out of a settlement. And I think that as a mediator, I would be remiss not to find a way to shed light on those subjects. And it's a balancing act, and it's a bit of a tightrope walk. And I certainly, there's limits. Like I certainly I'm not going to come in and say, well, Steve Dunn, think that the case should settle at X. I mean, I never ever do that. But one big part of it that I don't shy away from in the slightest bit is to read the tea leaves of what I think might be possible. I think it would be useless if we didn't say like, look, I don't know if they're going to get to $100,000 on this case. Like I'm getting more of like a 50 vibe over there. Maybe you squeeze them to 75. It's like if I'm not contributing those types of observations, then I'm not even sure, if I'm adding value. Because to me, it's about the art of the possible. It's about figuring out what's possible, and then giving everyone involved in the process the time that they need to get used to the new reality. because it is often the case that what you really hope to, like, so for example, you talk about like defendants and the perception from your side of the fence that defendants are driving the process. Well, here's the thing. From the defense perspective, they may have their bottom line and it may be rigid and unchanging, but they all come in with hopes and dreams of getting it done for less than that. They always think that like maybe it's possible that they're going to get it done for less, and that's what they're shooting for. Whereas it is much more common for it to take every single dollar of that authority to settle the case, and oftentimes then some. They got to make the phone call back to the mothership or whatever to get more money. So, as everybody's got notions about how the thing should get resolved, and I see a big part of our role as mediators as figuring out what might actually be possible today, and then as soon as possible, so that everyone can have time to get used to it. Because a lot of times I'm totally convinced if I told you at 9 a.m. what the number was going to be, the folks on both sides of the room would say, absolutely not, no way, we're packing up our stuff and we're leaving. It's only through the process that everyone's able to get there.
I agree so completely. That's why when I counsel my clients before mediation, I say, bring snacks, bring something to do that's not related to this case. I tell lawyers, spend some time chit-chatting with your client, get to know them more if you don't already, because you need that base of trust and rapport for all of you to be able to go into that territory of numbers that you thought would be, an absolute disaster. So you just need to kind of work together as a unit to get there, which leads me to my next question for you, which is for both mediators and lawyers, I see a lot of time and preparation on the mental game, right? The when they're doing the preparation, they're doing the law and the facts and, the arguments and the pressure points and identifying their own weaknesses and how they're going to counter that and all that. I don't see as much work on the emotional intelligence side of it. And I would love your perspective on how much that plays a role in getting to those settlements and how much of an impact that can have on you as the role as an advocate for your client.
Well, I think it's a big part of the job of the mediator I often describe my job as getting to know people real fast in the morning, like establishing a channel of communication and credibility and rapport with someone who I've just met. Oftentimes that's lawyer and client at the same time. And then once we have a productive working relationship with each other, then we're able to have the conversations that need to be had to settle the case. And sometimes at the end of the process, those can be tough conversations. They can be candid conversations. So I think that is a huge part of the job, and emotional intelligence is a big part of that. And personality certainly comes into play. I think it's essential in settling cases. And if the lawyers have that, then great. I mean, all the better. But if the lawyers don't have that in them, just because that's just not who they are, or that's not what they consider their job to be in that moment, then that's where you got to have a good mediator to take on that role. And it's some of the most rewarding experiences I've had have been ones where the challenge has been immense in both rooms. The most memorable ones are the ones where there's real hard work to be done on both sides. Yeah, that's what you're there for. If the lawyers can help you with that, then wonderful. But if not, well, that's why you're there.
What are the ways in which lawyers should be taking more advantage of you during the mediation and they're not?
I would be, frankly, a lot more candid with me about where you see the case headed. To tell you the truth, if anybody ever asked me first thing in the morning, hey, do you want to know what our number is, or do you want to know what our range is? My answer would be yes. I'd like to know that, or at least what you think, because we can immediately start that process of saying okay, well, it might not be that. Whatever number you say, we can say, well, all right, that or something like it may be the range for this thing. So I would be a lot more transparent with the mediator. I think a lot of folks spend a lot of time basically bluffing the mediator. People are afraid that, let's say you're a defendant and you're willing to pay $50,000 to settle the case or something like that. You're afraid perhaps that if you tell me that, then the case is just going to settle at $50,000. And I get that. I understand that is a theoretical risk that you could possibly get it done for less. But my experience is it almost never gets done for less. In fact, it's almost always a very difficult exercise to get the other side down to that number, right? And so if I know that number sooner rather than later, then the more things I can do to start planting the seed, in the other room, the more time the other side can have to get used to that number, So the first time they hear 50,000, they're going to throw up a little in their mouths and shake their head and, act like they're storming out. But then, the fifth or seventh time they hear that number, it's not so shocking anymore. And next thing you know, that's where we're doing the deal. So, and, maybe it's self-serving to say that. And I'm sure there's multiple opinions about this exact issue. But I think if you've got confidence in your mediator, then you should just tell the mediator what you got, and then have a conversation about what we're going to share with the other side and how we're going to roll it out with the other side, rather than to try to play your cards close to the vest in front of the mediator, because that just inhibits the mediator's ability to do what the mediator does.
So I have to, take my mediator hat off and put my advocacy hat on. And I will tell you that I've often told clients, don't say anything in front of the mediator that I don't know you're going to say for that exact reason, because your goal as a mediator is to get the case settled, and you are going to use whatever you have heard. Now, that doesn't mean you're going to cross your ethical lines and share it with the other side if you're not invited to do so or allowed to do so, but you're still going to know that in the back of your head. And so I do wonder as an advocate sometime if my client blurts out, I just want to get home in time for Jeopardy and I'll take 25,000. I mean, you're gonna know that, right?
No, that's true. And that's the risk. But I also think that an equal amount of time when those statements come out, there are things that you may need to know as the lawyer in order to do an effective job for your client. I mean, there are, when we're struggling to make a deal, it's either because of the party or the lawyer or both. And it runs the gamut, right? But sometimes the lawyer's the one getting in the way. And sometimes it's the lawyer's pride or the lawyer's experience. The lawyer may have had many cases before with clients who make this amount of money, whose case is about as strong as this one, and they've settled in certain range. And the lawyer's idea is this case has to settle in that range. Whereas you may have a client who is above average stressed out about the thing, or who has really pressing personal needs, what financial needs, or just need to get out of this for whatever reason, that sometimes they'll let it be known what needs to be known by the participants in the process. And if that helps, absolutely, as a mediator, I will find myself often saying, look, you all need to talk about this, and you, client, you need to make sure your lawyer knows everything that your lawyer needs to know in order to effectively represent you in this case. So I'll admit it, I'm pretty shameless about trying to dig out every shred of insight that I can, but I believe that most folks who engage me know that about me, and not only don't mind, but actually that's what they're looking for. I fundamentally believe that everybody wants to settle the case, and I'm there to help get that done. And I can't tell you how many times I've spent all day long talking to folks about how they're not going to settle the case, and they're not going to do this, and they're not going to do that, and they don't want to, and they're happy to go to trial, and they're looking forward to going to trial, and they can't wait for all this to become public, and they're ready to go to the ends of the earth. And I hear that all day long, and then we finally get the case settled, and they're so happy. They're so relieved. In both rooms, smiles on their faces, even though they're doing this in a range that they never would have thought it was going to be. Both rooms are just palpably and visibly happy to have it over with. And I just think again and again and again, you know, if you just listen to yourself all day, you never would have got there. We all make mistakes. We're all susceptible to cognitive biases. And it's our job as the mediator to kind of keep our eye on the ball and keep us moving in the right direction.
How do you know when no really means no?
There are different styles of no. And usually what happens is you get to a certain point, you've been trading offers back and forth. You know, there's this ritual that's a lot like haggling over the price of a used car in our mediations, where almost always the number of dollars is kind of the main term. There are other terms in every agreement, but usually the number of dollars is the big one. And if we can figure out the number of dollars, the rest of the stuff usually kind of falls into place. And there inevitably comes a moment in the proceedings where one party or another will say, this is it. Like, this is all we're willing to do. If it's your plaintiff, you'll say, this is our bottom line. This is what it's got to be. We call that our final offer. And there are different flavors of final offers, right? And so a final offer, if you just say X number of dollars and that's it, and then you just look at me and there's no further commentary, then I'm going to tell you as your mediator, I'm going to assume that that's not really it, okay? But if you say, you know, the lawyers who've been doing this for a while know, if you're going to make a final offer that really is the final offer, you've got to use, like, you have to say the magic words to cast the spell, where you say, this is it, this is all, this is really it, because I know you, Steve, and you're thinking that, like, maybe you can squeeze me but what you need to know is that this is literally all that it's ever going to be, and don't come back with another proposal. And if you say those types of words, then I'm going to go over into the other room and report it accordingly. But I will tell you, and I say this in almost every mediation, that I've got a choice as the mediator. I like to be very transparent about this so people understand and are not surprised. I've got a choice in almost every case between two potential errors. One is giving up too early on a case that could settle if we just kept plugging away. And then the other error on the other side is beating a dead horse on a deal that's never going to happen and basically just wasting everybody's time. And what I tell everybody is, I'm going to beat the dead horse 100 times out of 100. I will waste your time as much as we can, because I've seen it work again and again and again. So I think that, as long as folks know that, then they also know that they got to tell you, that they're going to have to tell me it really is over. You need to be very firm and very declarative about it. But because if you've got a good mediator who's trying to get that case settled, if you don't make it just as clear and emphatic as that, then the mediator is going to be grasping at straws, until the ends of the earth.
And it happens on the other side as well, right? You have the plaintiff who says, absolutely not. I'm never, ever, ever taking a dime under 50,000, and the offer is 45. That's a conversation, right? But is that really never, ever, ever not a dime under 50? Or is it, well, if they get to 47.5, I'll grit my teeth and bear it, right? And so it reminds me of that old joke about the two cars that are speeding head-on collision, and who is the one who's going to win? And it's the one who pulls the steering wheel out and holds it outside of their car. If you're the one who no longer has a steering wheel and you're willing to crash into the oncoming car, you're probably going to win that battle. But it gets there first. It's, I guess that's part of the fun of being a mediator, is to try to figure that out.
Well, that's why I always like to phrase things in terms of ranges rather than bottom lines, because you think it's got to be at 50, but it eventually turns out it can be 49. Like, according to the art of the possible, 49 or 47.5 or 45 is all it's going to be, or 40 for that matter. That's all it's going to be. That's all it can be to settle this case. Well, guess what? I think we should have a conversation about it. I think we should talk about it, because then we're talking about, to me, we're not talking about the difference between what you think it ought to be. It really ought to be 150.
Right.
We're not talking about the difference between 150 and 50. We've already talked about that. We're way past that. Now we're talking about the difference between 50 and 47.5. And this is very powerful in the defense room too. Like, if they're convinced it's got to be 45, but it could get done at 50. Well, we're not talking about the difference between 0 and 45. Like, that's ancient history, right? Now we're talking about the difference between 45 and 50. So now the question for you, Mr. Defendant, is, you gonna go to trial on this thing? You're not willing to pay $5,000 to settle this case? At this point,
right?
There's limits to that. But those are the conversations that you've got to have. And if folks have really strong artificial or arbitrary bottom lines in mind, then all it does is preclude those conversations, and it forces people to make what I would consider irrational decisions about settlement.
What do you know now as a mediator that you wish you knew when you were a lawyer in that room?
I think the main thing is that cases are almost always should get settled, that it's in everyone's interest, including the lawyers, for cases to get resolved through settlement. I, as a practicing lawyer, was much more of a tough nut to crack in settlement negotiations. I definitely gave mediators their work cut out for them, because I was prideful, and I practiced in a firm where the culture was to take a lot of pride in not settling cases and to be willing to go to trial. I had plaintiffs' lawyers tell me that, in a complimentary sort of way, like they would tell me that they recognized that we were perfectly fine going to trial. That we like trial. I wouldn't say like we looked forward to it or loved it or like wanted to do it, but like, if that was what was going to happen, then that was fine, whereas the plaintiffs' lawyers I talked to say that not everybody is that way. But I think as a consequence of that, I was less flexible in counsel. I've found, frankly, the most experienced and best lawyers that I see, I mean, the people who've really been doing it the longest, that really have nothing to be gained from that particular case. You know what I mean? Like, people there, they have nothing to be gained from anything, because they're fully established in their careers and are legends. A lot of times they will be the most insistent on counseling, thoughtful conversation about actually settling the case. And I think that is smart lawyering for a lot of reasons. One, it gives the client permission to settle if that's what they want to do, right? So you let the client know that it's okay to settle the case. So it's not going to disappoint you as the lawyer. A lot of times lawyers will rant and rave about how the case will never settle for this and never going to settle for that. And sometimes the client's sitting there thinking, I would really like this to be over with, but I guess, lawyers tell me that would be, bad. So I guess we're not going to do it. The other thing it does, though, and I think this is critical, is that if it doesn't get done for whatever reason, that's the client's choice. And they've been fully, from that point forward, even if you have to go forward, I say this in mediations all the time. Here's what we're going to do today. We're going to explore this opportunity to its very fullest. And if we decide not to do this deal, and if we decide we're going to go forward from today, then we're going to do it with our eyes wide open and free from regret, because we know that we gave it our best shot. We know exactly what we're getting into. And I think the really good lawyers who almost kind of like try to talk their clients into settling, if they choose not to, then when you go forward, you've got a great relationship from that point forward. Like they can't very well, if you're on the defense side, they can't very well complain about your bill too much, because they knew exactly, what they were getting into. And if you're on the plaintiff side, then it's the same thing. You can say, look, this is what we signed up for, and we had our reasons when we did it.
Right. Particularly when you're facing the uphill battle, in our district of summary judgment and the like, and your client's banging the, fist on the table. We're going to litigate. We're going to sue those bastards. And you're like, yeah, until we get dismissed at summary judgment. But okay. So you say it's in the best interest of the lawyers. And again, my plaintiff's attorney hat is coming back on. They're getting paid by the hour. What do defense attorneys care if they settle or not?
Well, believe it or not, defense lawyers are human beings. I know that I know it's true. It's true. I was one myself, and I was very conscious of my own humanity the whole time. We all have a sense of the case. And even if we believe strongly in the rightness of our positions, we are able also to see the value in moving on. Even if we're representing corporate clients, we're very aware that those clients would much rather be focusing on the things that make the money or that add, that are their mission, the reason for existing, rather than on this dispute. And yes, you can come at it from the perspective, and certainly I have, look, if I didn't settle a given case at mediation, then I could say, well, okay, it's not the end of the world. I am going to get to write this brief, and I like winning. I like billing by the hour, and I like winning cases. So, or if we have to go to trial, and this is a client that has good resources and is perfectly happy to, there are worse things in the world than going forward and litigating cases. That is true. And there are certain lawyers who may be more inclined than others to approach litigation in that way. But at the same time, we are all people, and litigation takes an emotional toll on everyone, including lawyers. And more often than not, I think that as a lawyer, if you get a case settled, it's a job well done for you. You've accomplished. I mean, that's a win, and we ought to be thinking of it in that way. That's kind of what it's all about. Like I think that our mentality about trials should be more of like necessary evil, as opposed to like a vehicle for glorious victory. I mean, I like to tell people, like, what the truth is, and what happened here, and nothing that happens in this lawsuit is ever going to change your mind about this. So you could go to trial and lose. Like, here's what you think is going to happen. You think you're going to go to trial and win, and that it's going to be a great victory, and you're going to be proven right, and everybody involved is going to somehow know that you were right all along. But if you think about it this way, you could also go to trial and lose. And if you do lose at trial, it's not going to change the way that you think about the case. You're not going to think like, oh, I guess I was just wrong the whole time. I guess they didn't do it, this thing that I'm accused of. Rather, you're just going to think that the jury got it wrong, or the judge got it wrong, or your lawyer didn't do a good job, or it was just bad luck, or, or whatever. And so if you can let go of the idea that prevailing at trial is going to prove anything, even knowing that losing at trial doesn't prove anything, then mediation can represent a wonderful opportunity to get a win. And I think if we can think about it that way, then we can get cases resolved even more than we do. And we usually, almost every case settles eventually. Almost all of them do.
So now I want to talk about any spectacular horror stories or any wonderful miracles And feel free to use our bizarre ending of the mediation we had.
Well, of course I remember. You and I had a mediation that was one of the most memorable ever. And what I think it stands for is the perfect opportunity where you as a lawyer and I as a mediator both took the opportunity to be flexible and to let go of our egos and not feel like we have to be the ones deciding, right? So what happened in that case, and it was very memorable, and I consider this like, one of the miracles, is we had a pretty contentious case. We had some very smart people on both sides of it. The clients involved were savvy, educated business people on both sides who had personal as well as business relationships with each other. And we're talking all day about how we're going to settle this thing. And eventually, at some point, this is my recollection. You back me up on this or tell me where I got it wrong. But the way I remember it is that the parties eventually came to us and they said, can we just talk? Like, can we just get in a room? Like, just like send the lawyers away and send you, the mediator, away. And we talked about it and both sides talked about it. And we looked at each other and we were like, yeah, sure, we can do that. And so this was at your office in Chapel Hill. We vacated the conference room. The parties went in there by themselves. And then we went and just hung out somewhere else and just kind of looked at each other, and they talked for a long time. I mean, I think they dimmed the lights and like they reminisced about their history together. And, they really had like the real human conversation, and they figured it all out. And then they came out of there and they just told us what the deal needed to be, and we drew it up, and that was that. And I've always the only time that exact thing has happened for me. But there's been other things like that, kind of unconventional things that can happen. And I think as a mediator, it's really important to treat each case as unique, which they are, and to be flexible, to serve the needs of each case. And in that way, any one of the lawyers could have said, no way. And there are lawyers who would have. There are lawyers, plenty of lawyers out there who would have said, no, not going to happen, not going to allow it. I'm afraid if I allow that to happen, then those people are going to make a deal that I, the lawyer, don't like for whatever reason, right? Or they're going to give away some piece of information that I, the lawyer, think is really important not to disclose. And maybe there's good reasons for that, right? But if the goal is to settle the case and that's what our parties are telling us that they want to do, then hey, let's try it. I'm willing to try a lot of things if it gives us a shot.
That was a perfect storm of two attorneys and a mediator who were all open to that kind of unconventional resolution, because it was scary. I've never done that before. I've never done it since. And we all sort of looked at each other when we were sitting outside the conference room, kind of biting our nails, going, should we go in there? Should we stop them? What are we doing?
I think we looked in on them at one point and they're like, no, we got it. We're good. And what I remember is thinking like, this is on some level, like this is the easiest mediation I've ever done because I'm literally doing nothing at this point. Like they're just figuring it out for themselves, but they did. And they were unique clients as well. I mean, they were folks that all day long, they were way above average in engaging sincerely with the other side's perspective on things. And that's part of what you hope can exist at some point in the process, but not many lawyers or clients come to it really naturally in the way that those folks did.
No, it was very unusual kind of mix of people, talents, and personalities. But the deal they came up with, we all sort of shrugged and went, okay.
All right.
Sounds good.
Sounds good.
Anything else you want to share with us, Steve?
Parting thoughts, I will tell you this. I tell this story a lot in mediations. I sent my wife a text one time. I should go find it again and screenshot it and frame it. Because I sent my wife a text one time. It was like 7:45 p.m. on a mediation that started at 9 o'clock in the morning. And I texted her. My wife often will check in with me around the end of the business day and just say, hey, how's it going, right? Because most cases tend to resolve like sort of in business hours, but occasionally they'll go really long. Occasionally we go into the night. And so she's always curious, first of all, if I'm coming home for dinner, and then secondly, if I'm coming home like before midnight, And so she was checking in on me, and I texted her and I said, and this is a direct quote, I said, I'm still here spinning my wheels on a case that has a 0.0% chance of settling. So at 7:45 in the evening, I, the eternal optimist, had concluded that there was a 0 point. I typed in 0.0. I was giving it no chance. And that case, as I'm sure you figured out, did settle. It settled later that night because we kept plugging away at it. And I learned something from that experience. And since then, I've seen it happen many times. The cases that we think are impossible, that everyone thinks are impossible, including the mediator. Even the mediator sometimes thinks that it's impossible. They can still sometimes settle, not every time, but even impossible cases can settle through this process. And so for that reason, I've learned just to never give up and to just give it all we got until someone literally just throws me out, either literally walks out or presses the button to end the video conference. Until then, as far as I'm concerned, we're still going. And by the way, even if you do that, then I'm just going to start calling you. And then I'll start texting you. I'll text you in like 3 days and say, hey, what if we did this? What if we did that? Because I tell people like an unsettled case is like a pebble in my shoe, or it's like it's like that flap of skin on the roof of your mouth after you eat something that's too hot. It just bothers me until it finally gets resolved.
I've been on the other end of the mediator stalking. I know what that's like. It's effective. It's effective. Thank you again so much for giving us this time. This was really fun. Obviously, you and I could talk about this all day. And I'm really looking forward to using all of this as I go forth and try to mediate some cases for folks. So I really appreciate your time.
I'm looking forward to hearing how your mediation practice goes.
Thank you.
I'm strongly pro mediation. Anytime anybody comes to me and says, I'm thinking about taking that class, for me, it's always a yes. Like if you're thinking about doing it, if you're wondering if it's a good idea, if you think you might like it, then yes, you should do it because it is wonderfully fulfilling work.
This has been Worksights. You can learn more about Laura Noble and the Noble Law on LinkedIn, Facebook, or thenoblelaw.com. Thank you for listening.